Yeah, I figured. All right. What else? Anything else in your minds? Okay. So today we're going to continue talking about covenants. The first probably half of class, we're going to talk about a case which is mostly common law, but also is a significant chunk of it. We'll assume that you've learned something about. Have you read the 14th Amendment yet? In any of its capacity? Have you covered the state action doctrine? Have you done the civil rights cases? Oh, here's yes and no. You did today? Okay, so you covered. Oh, I want to check. So you covered the civil rights cases, right? Okay, good. All right, so the first case we're going to say focuses on an interesting intersection of property and right? You may not think much about it, but much of the federal constitution is at property rights, right? The due process clause, you should not be deprived of life, liberty, or property without due law. The takings clause of the Fifth Amendment, the government wants to take your property for any kind of public use, they have to pay you for it. In fact, you may not even know this, but there's a clause in the Constitution where the federal control property owned. Okay, there's a significant amount of stuff in the Constitution of property, but one aspect that I want to focus in particular is the means of property, the mode of equality. So often people think of equality as the government simply treating people equally, but as you studied in common law, I'm sure there are certain other components of it that go beyond just mere equal treatment. And one important aspect of that is the ability to own and use property. Just in advance, the allergies and the pollen's really bad today, and my throat's been going all day, so I'll do this to make it through. I lose it today. So for much of American history and most of Western history, not everyone was able to own property, right? At early stages in our country, generally landed gentry were able to own property. You study property that women originally were not allowed to own property, and that changed throughout the 19th century with the Property Act and other things. In particular, had a very rough was blacks, specifically after the Civil War. Many states passed a number of laws that made it effectively illegal for the freedmen to own, sell, and dispose of property. Okay? And as it is, there's a serious right? In order to deprive people, it wasn't enough simply giving equality under the law. They need to have the full panoply of civil rights. And that specifically includes the right to property, to sell property, give you others, to form contracts, to serve on, to do all the different things which are full member of society. And those were deprived by the Jim Crow laws for many, many years. Okay? And as I'm sure you studied in common law, the Supreme Court blessed that and sanctioned that with opinions like Plessy versus Ferguson, right? Plessy versus Ferguson is the one we all study. You know, on a rail car, you have Homer Plessy, who was basically 1/6 black, who looked fairly Caucasian, but he went in the train on purpose, getting arrested. And in the decision, which is quite notorious, the Supreme Court upheld this doctrine of separate but equal, that so long as the accommodations are fairly equal, they can be separate. But the case most people don't remember from this period, which is equally as important, is these civil rights cases. And I'm hoping you studied that, but if you haven't, I'll give you a summary. Plessy versus Ferguson dealt with public accommodations, public trains. The civil rights cases dealt with private accommodations. Could a private hotel discriminate? Could a private opera house discriminate? Could a private theater exclude people based on this color of their skin? Right? So these are one of the early constitutional challenges under the 14th Amendment. So I want to discuss here for a minute the state action doctrine. Okay? So on its face, the 14th Amendment says, right, no state shall make or enforce, yada, 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 right, no state shall deny to any person within its jurisdictions equal protection of the laws. Okay? For our purposes, the most important words are the first two. No state. By its mere text, the 14th Amendment applies to the states. It places limits on what the states can do. The states cannot discriminate. The state cannot deny equal protection. Okay? What about private parties? Right? What about a theater or a hotel or an opera hall? In the civil rights cases, it was an 8-1 decision. The court held very clearly that the 14th Amendment does not apply to individuals and private businesses. In that case, the court said that there's something called the state action doctrine, that only when the state is acting to deny equal protection is a violation of the 14th Amendment. So at the time of the 14th Amendment, private businesses were free to discriminate as they wished. Right? There was no constitutional limitation there. And one of the points that the majority made in the civil rights cases was they distinguished the 14th and 13th Amendment. So, of course, we have the 13th Amendment, which eliminated slavery. And we can read the 13th Amendment. It says, neither slavery nor involuntary servitude, except as a punishment for crimes, blah, 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 shall exist within the United States. So the 14th Amendment says, no state shall deny equal protection. The 13th says, slavery, quote, shall not exist within the United States. You see the difference there. The 13th Amendment is one of the only parts of the Constitution that directly acts on individuals. The 13th Amendment acts on everyone. You cannot have a slave. Everyone in this room cannot have a slave. This is prohibited by the 13th Amendment. If you do have a slave, you can actually be prosecuted for violation of the Constitution. At the time, this was the first ever effort of the Constitution to act on individuals. Before that, it only acted on the government. Does anyone know the only other time where Congress tried to regulate private conduct through the Constitution? Well, that never passed. Well, yeah, he said it. Prohibition, right? Prohibition said you shall not have any kind of intoxicating beverages. So the Constitution has tried twice to regulate private conduct. The second one, fortunately, was repealed for all of us by the 21st Amendment. But the 14th Amendment does not act on private parties. 14th Amendment said, for example, you can't have discrimination on juries, right? You can't have discrimination in other kind of private places. But private institutions were welcome and free to discriminate on the basis of race. Okay? So that's the background of this. So for much of the late 1800s and early 1900s, even though slavery was abolished, many legal regimes were created with the express purpose of segregation. And one of the major tools used was property laws. Okay? So in addition to denying the freedmen the ability to buy and sell property, a number of cities actually imposed formal zoning codes as a means to discriminate. For example, the city of Louisville, Kentucky, where I lived not too long ago, passed a law saying in this part of town, only whites, and this part of town, only blacks, right? Separate but equal. You have equal different parts of town, and a person in this neighborhood, the black neighborhood, couldn't sell to whites, and the person in the white neighborhood couldn't sell to blacks. It's fair, right? It's equal, right? You can only sell to people of your own color. Well, under Plessy, that was actually probably a correct statement of law. But in a case which probably most of you have never heard of, but was very significant, called Buchanan versus Warley, W-A-R-L-E-Y. In Buchanan versus Warley, the Supreme Court actually found this practice unconstitutional. Why? They found that was a violation, right, for this, of the freedom of contract, right? That thing which you're told to hate emphatically. They actually said it was a violation of the liberty of contract of whites and blacks to sell to whomever they wanted, right? That the state could not tell you who you can and cannot sell your property to. That one of the most essential sticks in the bundle, right, is the ability to sell property. So the court actually said in the Buchanan case that you have a due process right, a liberty interest, if you will, to be able to sell your property as you see fit to whom you wish. This was a very powerful tool as a means of allowing individuals to buy a piece of property in a white neighborhood. right? Or for a white person to sell their home to a black person. Okay, this is a case which probably didn't even mention in common law, but it's very significant. This is one of those aspects of Lochner that people who hate it try to forget about as hard as they can, but there were positive aspects to that doctrine. So as a direct result of Buchanan v. Worley, cities were no longer able to make segregated white neighborhood and black neighborhood. So what did people do? They turned to another area of law, which did exist, which were racially restrictive covenants. As a direct result that cities were no longer to segregate by law, right, they turned to restrictive covenants, where individuals would record covenants on their property that would limit the sale of land to white people, right? And that's effectively what happened in the case we're saying today, Shelley v. Kraemer. And before I get too far into the constitutional law aspects of Shelley v. Kraemer, there are actually some interesting property stories to be learned. So we learned in our class last week that at common law, you needed things like horizontal and vertical privity to be bound by covenants, right? These are restrictions that are mostly got rid of in the 20th century. But by getting rid of these things, you made it a lot easier to pass these kind of racial restrictive covenants. Okay, why? You'll notice in the facts, which we'll do in a couple of minutes, that not all the people on the block agreed to these covenants, right? That there were some people on the block who didn't even have these covenants there. Under the common law, if you didn't agree to a covenant, you're not going to be bound. So in the common law, you could not even have these kinds of covenants where some people signed it, some didn't, but the entire block was bound. Even on the topic of equitable servitudes, right? We learned that an equitable servitude must, quote, touch and concern the land. And in the 20th century, courts severely relaxed this to make it mean whatever they wanted. But at common law, the color of the skin of a person living in the home in no way touched and concerned the land because it had no impact on what it could or could not be done on it. So you see in a couple ways this case could be resolved under fairly neutral property principles. Okay? But this is not how the case was resolved.
In the case, we're talking about race. I would assume that apply also, like you can't have a covenant that excludes like homosexuals.
Oh, we'll get to that. We'll get to that. We'll get to that in a few, maybe 25 minutes. Okay. So there were fairly narrow property grounds to say that the burden of the covenant doesn't run because there wasn't a horizontal privity, or you can simply say this requirement didn't touch and concern the land, right? But they weren't going to resolve this case on the narrow basis of property law. That would have been too not what the Supreme Court sought to do here, right? The NAACP didn't bring these cases to test the contours of burdens and benefits running with the land. That's not why these cases were brought. And I don't mean to make light of this, but the breakdown of the common law property rules enabled these restraints and alienation, which would not have otherwise been allowed. Okay. So the case of Shelley v. Kraemer, which we can talk about in a lot more detail now, was actually two separate cases. I think the book only gave part of one. Okay. So the first one dealt with a block of homes on Labadie Avenue in St. Louis, which not too far from Ferguson, as it turns out to be today. So, all right, where did I finish last time?
I'm next.
You're up. You're up. I'm going that way.
No, I'm next. You finish with Schmeier.
Okay, so I finished it. Yeah, cool. Thanks, Eric. Okay, so Eric, what were the facts with the Shelley fact pattern from Labadie Avenue, please?
The Shelley, the plaintiff, was suing Kraemer.
No. Go way back. What was the property arrangement on these blocks?
There was a restricted covenant that you could only sell to Caucasians.
Be more precise. Which houses had those covenants on it?
On one side of the railroad tracks.
No. Do you know the details?
30 39? It was not the complete whole.
Good. So there were 39 property owners on this block on Labadie Avenue. Okay, 30 of them agreed to these covenants, right? So to starters, not all of the people who lived on this block agreed. This actually, by the way, this is the Shelley house. It's been turned into a museum today. And if you go there, it's right outside St. Louis. You'll see this plaque, and it says the Shelley house. This 1958 home of J.D. Shelley was the locus of one of the most famous equal protection cases. And you can read that later. Okay? So this was one of the houses. And in 1911, a majority of the owners in that block, but not all of them, so 30 out of 39, agreed to this covenant. Okay? Or tell me, what were the terms of this covenant?
Like Rick said, if you were not Caucasian, you couldn't just buy the property.
Yeah. Ownership was limited to people of the Caucasian race. Anyone who is a, quote, Negro or Mongolian race was not allowed. Mongolian, I'm assuming, means Asian, but it's an antiquated way of even writing that. Okay. How long was the covenant good for, Temio?
50 years.
Okay, so what's interesting is the covenant's only good for 50 years. It was signed in 1911. So it's been over in 1961. Right? What year was this case?
1945.
So it had still a good another 15 years or so before the covenant would run out. Okay? All right, so I'll come back in a second. The other case, okay, there was another case from Michigan called McGee v. Sipes, which had a very similar arrangement, where you had a block in Detroit where a covenant was reached by roughly 80% of the people on the block. So even back then, not everyone was willing to sign these covenants. But in both cases, you had less than the majority of the people on the block. I'm sorry, less than a majority, but less than all the people on the block agreeing to this. Now, from a property perspective, we should not have people binding you without everyone agreeing. But we'll put that aside for now. In both cases, Shelley took without notice of the covenant, and the guy in Michigan took without notice of the covenant. Okay, it's dubious if that's actually true. More likely than not, if you were a black person in St. Louis buying a house from an all-white lot, you probably should have been on notice something was up. And I don't say this lightly. I don't know if anyone looked, but the final vote in the case at the Supreme Court was 6-0. 3 justices recused. Does anybody want to guess why 3 justices recused? 3 of the justices of the United States Supreme Court, Justice Whitaker, Jackson, and I think Rutledge, recused because they lived in homes in Washington, D.C. with these racial restrictive covenants on them. That's pretty intense. We're not talking like in Montgomery or Selma. I'm talking Washington, D.C. in 1948, that they lived in homes. I bet that if any of you live in Texas and you did some title searches on your homes and you went back through the chains, you would find at some point a restrictive covenant that pops up. I mean, I'm positive of it if you look, especially some in this area. Okay? This is a dirty part of our history which property helps maintain because we keep very good records. All right? So in both these cases, allegedly, Mr. Shelley and Mr. Sipes took without any notice of these covenants. Okay? The people selling it to them obviously didn't care, right? People selling it were willing to sell it with the covenant on it. They didn't really care. They were making a profit, right? What do they care? But the way covenants work is that if you're a neighbor and you benefit from a covenant, in this case by not having black neighbors, and that covenant is then violated, you can sue on the covenant. And you can actually seek an injunction to cancel the sale of the home. If you benefit from the covenant, you can actually sue to prevent the transfer to this new black neighbor. Okay? So the question in this case, and we go back to the 14th Amendment, Is there state action? Is the 14th Amendment operating on individuals here, or is the 14th Amendment operating on state action? So let's walk. We'll get there. We'll get there, right? So let's walk through this one step at a time. Go back on top, Sean. All right. So let's walk through this slowly, okay? When the neighbors decide to say, "Hey, Shelley, we don't want you moving in here. Scram." Is there any state action there?
No.
Okay. When the neighbors hire a lawyer and file a complaint in court saying, "Hey, Shelley, we don't want you here, scram." Is there any state action there?
Not yet.
Okay. When the judge enters an order saying, "Yes, based on this covenant, which is otherwise valid, I am issuing an order to eject Shelley and eliminate his title."
Yes,
Is there state action there?
that's the state action.
Tell me why.
Because, some precedent said that if the court is making you do something, that's a state action. The judicial process is, judicial proceedings, if they were to, judicial proceedings, that comes to state action.
Okay, good. So here's the rub of this case. What the court did here, without completely explaining what they did, was they said, when private parties want to discriminate against each other, there's no state action there, right? But to the extent that you involve the government, you go to a court, you ask a judge to enter an injunction, you ask a judge to enter in an order. Once the judge then enters in that order, there's state action. The same way that a judge cannot discriminate and exclude all black jurors, Strata versus West Virginia, a judge is not able to enter the case, put up an injunction, and expel the blacks from this neighborhood. Okay? That the mere fact that you're asking for the court's permission is what makes it state action. Okay? I guess another example, Alex, let's try this example. Say someone is on your property, right? And you say, "You know what? You're black. I don't want my property. Scram. Get off." And they don't do it, right? You call the cops. Cops show up. You say, "I want this guy on my property because he's black." Are the cops allowed to remove him?
Saying that, but
I'm not saying you, but in general, assume a hypothetical. Even if your rationale is nothing with trespassing, just, "Yeah, I don't like him because he's black."
I mean, technically, put the police operate on.
So I asked an example on purpose, right? On its face, the covenant is perfectly valid, right? There's nothing wrong with the covenant. Under the law, it was a valid covenant. But what renders this illegal is you're now asking the government to take action based on the discrimination on races, which is now a no-no, right? What makes this case trickier is the court doesn't sketch out the scope of what state action is, right? So, is it Haley? Oh, Katie, I'm sorry. All right, Aisha, yeah. Aisha, let me ask you this question, right? How far does this go, right? How attenuated must state action be? So let me ask you this question. Say, everyone know about the Augusta National Golf Club? So up until fairly recently, it didn't admit any women. It actually changed that policy, I think, a year or two ago. Can a private country club exist like that and not admit any women? What do you think? Is that permissible?
I mean, I think if they have like anything that involves some type of government action, like if they serve alcohol or something like that.
Oh, so you would say that the country club can't apply for a liquor license if they don't admit women.
Like that, yeah, like there is, I guess, government intervention at some point there, so it's not.
What about if they want a zoning permit to change their, to change the front of the structure? Would that be sufficient?
I think it could be. We can make an argument for it.
All right. What do you think, Katie?
Maybe a little bit more detail where they would actually manage the place somehow.
Uh-huh.
Like she was saying, with her intervention,
Okay.
somehow intertwined.
All right, so curious, who here agrees with Aisha and Katie that if you want something like a liquor license, you shouldn't be able to exclude women from a club? Interesting. Okay. Adam, let's try this one. The Boy Scouts, right? It's not what you think. That one's coming later. Boy Scouts don't admit women, right? In Girl Scouts, you have Boy Scouts, right? Boy Scouts have tax exempt status. They often meet in public parks and state parks, go camping. So the Boy Scouts, by getting these benefits from the state, be allowed to exclude women from their ranks.
Like join with it.
Women cannot join as members of the Boy Scouts. That's not allowed.
Well,
And I was never a scout, so I have no dog in this fight.
because I wasn't-
I'm asking you though,
Um,
based on what Aisha and Katie just explained,
well,
Augusta National can't get a liquor license because they don't let women in. Why should the Boy Scouts be allowed to have tax exempt status or use public parks?
I'm thinking like along the lines of other cases I read in constitutional law, but I mean, I feel like the government could force their hand somewhat to what they did in South Dakota with like the drinking age. So I guess like the government could come in and say, that's fine if you don't want to do these things, based on the civil rights, acts and stuff like that. Then sure.
I'm not talking about civil rights, I'm talking about the Constitution. Not talking about the Civil Rights Act here. Adam, let me ask you this question. Right? Is there anything else in the Constitution that might make us leery about telling the Boy Scouts who to admit, by telling Augusta National who they have to admit, and by using the arm of the state to coerce them? Oh, come on.
Other than what's been discussed.
Who knows what I'm talking about? Freedom of association, right? It's right in there in the First Amendment. You don't have to read too far, right? Page 1, Bill of Rights. So we often say that the Constitution, right, is a game of balancing, and we're always figuring out ways. And while we all agree that private discrimination is odious, right? In certain contexts, groups often discriminate and decide who can and cannot be in their ranks. And often it's very difficult not to have governmental benefits, right? To have a zoning change or to have a liquor license. So I've assiduously avoided the religious argument, but this very well may come up in the not too distant future, where the Catholic Church doesn't admit women clergy, doesn't admit gay people into the clergy, right? They want tax exempt status. Should they be able to maintain it? Right? Is there any reason why private groups may be allowed to exercise some form of discrimination in their admission policies? I'll give you another one. A couple years ago, there was a case involving the Christian Legal Society at the University of California, Davis. And the Christian Legal Society had a policy that said, anyone can join our group, but if you want to be elected an officer, you have to believe in Christ. Seems like a reasonable requirement that if you want to be an officer of the Christian Legal Society, you have to believe in Christ or something like that. And the school said, no, you can't do that. You need to have what's called an all-comers policy, right? And the Supreme Court actually agreed with that. They said that a group defined by Christ is not able to exclude non-believers from their ranks. And some of you may think that's a great idea. Some of you may think that's a terrible idea. But at every level, when you have some sort of group, there's always issues of inclusion, exclusion, of who you want, who you don't want. And it's not as straightforward as you may think. So someone asked about a restrictive covenant for gays. So I'll pause for this example, which comes up with increasing frequency. You had I'll get to everyone's questions in a minute. You had a baker, she was in New Mexico, or was it Colorado, I can't remember, who a gay couple asked her to bake a cake for their gay wedding. And she declined, saying, I want no part in this. If you want me to bake you cupcakes for Christmas, whatever, I'd be happy to do that, but I will not bake a wedding cake. Okay. The law found her liable under the discrimination ordinance. Another case, this one was from New Mexico, involving a photographer, where a gay couple asked her to photograph their wedding. She said, I'll do that. If you want me to photograph your Christmas party or your birthday party, whatever, that's fine. I won't sanction and participate in this thing, which I don't find acceptable. The state said, we won't do it. You cannot do that. You are required to photograph the wedding. Now, why would someone want to photograph their wedding? Someone who doesn't even want to be there, crappy pictures, whatever, but that's not the issue. We're going to start seeing this a lot more. I'll get to everyone in a second. As this line of where there's state action, where there's not, starts to push, and more aspects of private association are deemed subject to various demands of equality, they will eventually have to give way to some sort of intrusion upon the ability of people to choose who they do and do not interact with. And I'll leave this for all of you to think about. But before you start taking the clear position that, oh yeah, if you apply for elections, we can choose who your membership are. Think about some of the groups which you might be a member of, which are choosing for who they admit and who they don't. And it becomes a very thorny issue fairly quickly. All right, Zoe, your hand was up.
Yeah, I just remembered when I was a kid hearing something, there was just this huge thing about it, about how technically the Boy Scouts do have to a girl if she insists on joining. Like if she persists, the court would make them do that. I remember reading about an instance where this happened, but they tried to discourage it. You would have to be really persistent. But I remember hearing about this girl who joined the Boy Scouts.
Mm-hmm. Well, I know that there was a Supreme Court case about this called Boy Scouts versus Dale, which involved whether the Scouts could exclude a Scoutmaster who was gay. And the Supreme Court said that, I'm sorry, my voice, that the Scouts were allowed to do that. They could choose the qualifications. There was another case involving a St. Patrick's Day parade in Boston, where the parade organizer excluded any gay groups. And again, the Supreme Court in a fairly large majority held that that was permissible because these people can decide who is and who's not in their groups.
That's because different groups have this different level of whether suspect or not. And as of right now, or at least very recently, the courts think that sexuality is a less suspect group than like gender, although from recent decisions, I think that's starting to change.
Well, this is actually First Amendment case. It's not even equal protection. These are a matter of freedom of association. So the actual your scrutiny there isn't quite as important, but you're right. Yeah.
As far as like you said, that you made that photographer take those pictures for the wedding. With that, like in contract law, they usually don't, the injunctions for
Specific performance. Yes.
Involuntary service.
And there's also while you're at it, a free speech. There's a First Amendment compelled speech argument, where generally courts don't compel people to speak, and photographs are a form of speech. It's an artistic expression to photograph. There's a serious number of constitutional issues with that one. In fact, there's actually there was a case, I think it was from Indiana, where there was a gay pride parade, and the groups asked a Christian T-shirt printer to print up T-shirts for the parade with whatever gay pride, rainbow, whatever logo it was. And he said, I'm not going to do it. So the remedy in that case was actually force this group to print up T-shirts and engage in a form of expression, which has really interesting First Amendment implications. But that's somewhat a field where I want to go with this. Who else? I saw lots of hands up, and I brushed. Yeah, go for it.
At the same time, wouldn't that same like service contract and volunteer servitude thing come into place if someone's trying to join the club? Which
Mhm.
are not like exactly wanted, for instance, atheists joining a Christian society.
Yes, well, this was on a college campus. So it was a slightly different situation. But generally, people are free to choose the members of their own organization. And when there's a religious aspect to it, it becomes even more pronounced. But under various laws, and I think you'll see this in the not too distant future, various groups which choose to discriminate based on and not admit women or not admit gays will start seeing government licenses yanked. You want to have a tax-exempt license? Too bad. You want to have a liquor license? Too bad. I think we will see that increasingly as we march on. Other hands.
A case like Lodge number 66 or whatever, where they said that liquor license wasn't enough under the employment period or whatever to qualify as state action.
I'm not familiar with that case, but I can see under state law that religious organizations start losing their nonprofit statuses. I can see that happening fairly soon. Who else? So the actual outcome of Shelley was somewhat muted because not too many years afterwards, Congress passed the Fair Housing Act. And as a matter of statutory law, it made these racially restrictive covenants unconstitutional. So it's been very rare today to bring a lawsuit under the 14th Amendment to challenge a racially restrictive covenant because you can bring it under the Federal Fair Housing Act. Okay? But I bet if any of you did some research inside your homes, especially if they're in the South, you will find these in your chain of title. Okay? All right. Actually, the book mentions there's one funny covenant where someone in Georgia restricts the sale of their land to any Yankees, which perhaps people here might appreciate. I was in Georgia past couple of days, so I can recognize that. All right. Any other questions on Shelley or race restrictive covenants or state action or the 14th Amendment or anything like that? Okay, good. As an aside, at various points in law school, you should be uncomfortable. You should be discussing things that make you feel uncomfortable, and I go out of my way to do that because it makes you appreciate the issues we're discussing. So I appreciate the respectful discussion we've all had today. Okay. All right, now to not so interesting things. We can talk about termination of covenants. The book lists 9 things. I don't expect you to memorize these, but you should at least be familiar with the various ways that covenants are terminated. For the most part, so long as a covenant is still valid, it stays in the books forever. When we say a covenant runs with the land, or a burden of benefit runs with the land, we mean it. It will go on like Celine forever, on and on, right? There are very few ways of eliminating covenants, okay? So one way is merger, and this is the most obvious way. If person A has the benefit and person B has the burden, person B can buy off the covenant and say, hey, you know what? I'm going to pay you money and you're going to release me and we're going to merge together the interests. Right? The second one, release, is effectively the same thing. You pay someone to give up their covenant. Right? These are repetitive, 1 and 2. The third one is what we call acquiescence. If for many years there's a covenant that's not being enforced, right? Covenant says you can only have residential usage and you build a factory there. And the factory's there for 1 year, 2 years, 5 years, 20 years. After a while, the other person stops enforcing it. You actually have a case for acquiescence, right? That the owner of the covenant has given in. This is like another way of thinking of perhaps prescription, right? If you keep doing something for long enough, you've actually gained the right to do it. In a sense, you can nullify the covenant. Another issue is abandonment, right? This came up in the railroad case we did last week. If, you know, someone just abandons a piece of property and doesn't tend to it, the covenant can just go away. The unclean hands, yeah.
What if it's adversely possessed by somebody else after a while? Then he's the covenant.
Yeah, no, that would kill the covenant.
It would kill the covenant if somebody else adversely possessed it.
Okay, be precise. Are you talking about prescription or adverse possession? Because that won't. So squatting on the land doesn't kill the covenants, right? But if you do the thing you're not supposed to do, you can actually gain the prescription. You can actually nullify the covenant by prescription, right? Adverse possession has nothing to do with covenants.
If you have constructive notice that the covenant is there, still.
Right. So say the covenant says, you know, you can't run a factory, and then someone else comes and runs a factory for 20 years, right? You've now gained that right by prescription. You see?
Yeah.
Okay. Stops. But whenever the pollen gets really high here, my voice just goes away. I've never had this anywhere else. For a long time, I thought I was sick. Then I actually checked the pollen count. I realized it's just the pollen. So another one is unclean hands. And this is an equitable doctrine, which you'll see in a lot of classes. So say, for example, you know, the covenants say, you know, only residential housing. And then someone goes and builds a factory. And someone across the street also builds a factory. And one guy sues the other. And it's like, no, you can't do that. You violate the covenant just the same. Latches, which I'm sure you've studied in other classes, discusses a reasonable delay. Before there were legal statutes of limitation, you had these equitable period called latches where you had to bring your cause of action within a certain amount of time. Okay? You can't wait forever. Okay? Estoppel, this is just another form of reliance, that if the defendant relies on the plaintiff's conduct, you can't allow the plaintiff then to enforce the covenant. So that's like, you know, I say, hey, I'm going to build a factory. Are you going to sue me? I'm like, no, I won't sue you, I promise. And then you go and sue the person anyway. You can't do that. Okay. Eminent domain, this one probably will never come up. But if the government seizes a piece of property using the eminent domain power, that terminates whatever covenants. And the last one, which we'll be talking about in the next couple of cases, we're called changed circumstances. This is one people most try to take advantage of, right? It's like, well, when we made this covenant for residential only uses, this is like, you know, a small town with only a few people. And look what's happened in all these years. You have all these people have moved here. You have all this new development. You know, the circumstances are changed, and this covenant's no longer valid. So historically, under the common law, this last one, this changed circumstances, wasn't very effective. As long as the covenant was valid, it would be enforced. And even under the modern law, there's some wiggle. But generally speaking, covenants are enforced, unless there's some other really bad reason why they should not be. Okay. Any question on those 9? Again, you don't have to memorize them, but at least be familiar with them. And the most important one for our purposes is the last one, because that's usually how people try and get away from a valid covenant. Okay. All right, let's do the first case, this Western Land versus Truskolaski. Okay. Kevin, you want to give me the facts, please?
Yeah, this is the covenant restricting land usage to single-family houses, prohibiting any stores or whatever. They sold 3.5 acre parcel of it, where they tried to put in a shopping center. And the district court didn't want to put up the shopping center.
Okay. So in all these cases, it usually happens like this. At some point long ago, there was a subdivision where they limited everything to residential. And then the area became very commercially vibrant. All these people moved in. And someone's tried to build a store or a hospital or something new. And you couldn't do it because of the covenant, right? The argument always goes something like this. Things have changed. The circumstances have changed. And the circumstances that justified this covenant, 30, 40 years ago, no longer exist. Okay? So Monica, was the court persuaded by that argument? Was the court persuaded that because things have changed, we can now have to nullify this? You let me finish. Kanye, thanks. So, I'm gonna let you finish. Oh, God, is that already too old?
What?
Forget it. Was the court persuaded by that argument?
No.
Good. Tell me why.
Even though the nearby avenues and residential character of the neighborhood was not adversely affected and the purpose of the restriction was not thwarted.
Okay. Why was the court not persuaded? You tell me no. But why was the court not persuaded? What? How come did they think that the covenant was still useful or still relevant? Tell me more. Tell me more. Explain why.
Because we're still residential in the neighborhood and just because there was more traffic didn't mean that it wasn't a neighborhood.
Okay, good. Thank you. So the answer is yes, right? They were not persuaded by this argument. Even though this land could definitely be put to a much higher use as commercial property, that wasn't sufficient, right? It was still of some benefit to the people as residential property. And as a result, the covenant would remain.
Is it some, or as long as it's a benefit to one party?
Okay, and this is the interesting part, right? I'll go to later. Does it matter if there's actually any real meaningful benefit, or is it enough that there could be a benefit? And that's the issue, right? You don't even need to show that anyone's actually benefiting, right? That someone could benefit from it is sufficient to maintain the covenant. That's why the next case we'll see, there's almost no benefit to be had, right? But we simply assume that when someone takes a piece of land subject to a covenant, they take with the notice that their use is restricted. Okay? And merely because some people might benefit from it, it's not enough to nullify it. Okay. And it seems that afterwards, they came to an agreement of some sort to allow the land to be used for some sort of commercial purposes with low traffic. So again, people can usually work things out themselves. You don't need the court to step in. Because when the court steps in and strikes out the covenant, they've now diminished the property value, right? You may have had a piece of property with a benefit on it that you wouldn't have a bunch of businesses nearby, and maybe you act in reliance upon that. But now your property value has been cut off. All right, any questions in this case? Hand? No? Any questions in this case? Not too hard. All right, take a look at the next case. Victoria, what happened in Rick v. West?
Rick had a 62 acres of land and he sold it to West.
Mm-hmm.
It had a covenant on there where he sold some more, but it was like for industrial stuff, and then some more of the acres, some more acres were sold for hospitals. And West said that now it has to be residential.
Okay, good. So here again with a situation where there's some piece of land sold, and you have this woman, West, right? And she would not consent to allow them to build a hospital nearby. Now, I think everyone would probably agree that a hospital is a good thing to have in the area. If we're ever sick, we probably would want a hospital nearby. And this probably benefits every single person in the area except for, Victoria, who does it not benefit? West. Does she actually get injured by this? Okay, and that's what Tessa's thing, right? It's unclear if West would actually suffer as a result of the hospital being built. If anything, she's an old lady. She might, I shouldn't say that, my dad will get mad at me. She's a woman of age, so she might actually need the hospital at some point, right? My dad will be mad at me anyway. So as a result of West not consenting to the construction of this hospital, did they release the covenant, Mike? Did they get rid of the covenant? Did they get rid of the covenant?
Nope.
Why they keep it?
Because she didn't consent to releasing the covenant.
Yeah. Good. Right. So because she won't release a covenant, even though she has no tangible benefit, she's stuck. What's interesting is that they actually modified the law afterwards, and they discussed this in the notes following it, where they effectively said, you know what? You actually have to have some actual benefit in order to hold on to a covenant. If you have a covenant that really benefits you in no way, you can't enforce it. So there, the New York legislature is actually trying to prevent this from happening. And this is not crazy. So I want to show you this picture involving holdouts. So it often happens that you have a developer comes in and wants to develop an entire plot of land, right? I'll show you the aerial view. And every single house on the block agrees to sell it to the developer so he can build some fancy new thing, right? Except for one. And there was this lady of some age who lived there. I think she was in her 80s. She had no family. She really had no one. And she had her house, and she had no interest in moving. And they asked her to sell, and they asked her to sell, and she refused. So it got to the point where they just built they built the thing around her. And you can actually see it better in this picture, right? Her house is next to the crane. So the crane is here. Her house is there. And they built this entire shopping center around her house, right? And these are called holdouts, right? So she sat there through all those years, all the construction, with all the banging and noise, and didn't go anywhere. As a bizarre footnote to the story, the foreman of that construction project would often go there to try to talk to her, and they ultimately became friends. So and this is true, he wasn't just scamming her. He actually became friends with her, was helping her out and stuff. So when she died, she left the house to him in her will. So they were able to then eventually destroy that house, but I don't think they changed the structure of the thing. But you have these holdouts in very many places. Now, if they had been smart, the developers, they would have just gone to the city, I think it was in Seattle, and said, hey, why don't you use eminent domain to seize her house? You can take a lot more property value from her house, right? We make all this money from this LA Fitness than we can from having this dilapidated shack. And under a case we'll study in a few weeks, Kelo v. City of New London, that will be entirely permissible. You can seize property by the government for economic development. As gross as that sounds, I would much rather have this little shack next to LA Fitness than have the power of the arm of the state to seize private property for public development, private development. Okay? All right. Questions on that case? All right, let's do the last case. All right, Zach, what happened in this last case, Pocono Springs versus MacKenzie? Different Pocono Springs case.
The defendants decided they wanted to pay in their taxes and homeowner association dues, so they tried to abandon the land, and they basically weren't able to abandon it.
All right, give me more of the facts, though. Why did they try to get rid of the land? What was their problem?
They didn't want to pay the homeowner association.
Why couldn't they sell it? Why? Good. All right. So here we had a situation where they bought some land at Poconos. And from the facts, there's some sort of speculative development deal. And as a matter of living there, they had some covenant, which require the payment of various annual dues, right? They had to pay various fees and dues each year. They wanted to sell it, but the soil underneath was not suitable for septic tanks. Someone explain what that means. I guess you need like a consistency of soil to have a tank. What happens if it's too runny? You don't want a runny. Yeah, no, you don't. There it is. Okay, there it is. Here it is. Right. Okay. So they couldn't sell it, right, because the soil was too loose. And they said, okay, we want to get rid of this land. They took a couple steps. They tried to turn it over to the homeowner association. They didn't want it, right? Then they tried to give it a gift to the association. they declined it. Remember we discussed gifts, or not we, but when you discussed gifts in property one of the elements was acceptance. We said acceptance was inferred, like if I give you a gift, it's inferred that you take it. That ain't always the case, right? So here, they said, no, it's yours. We don't want it. All we want are your fees. Okay, so then they cease paying taxes on it. Okay, so when you stop paying taxes on your land, the county offers it up for a sale. No one bought it, okay? Then they sent letters to everyone saying we want to abandon our interest in the land, and then they stopped accepting mail on this, right? Parsa, was this sufficient to relinquish their claim in the property?
No.
How come? Can you abandon your claim in property? Okay, this is something which you probably learned last year, but at any given time, someone has to have title to a piece of property. Okay, it's impossible for a piece of property not to have an owner, right? Someone has to have it. And generally speaking, when you die, it goes to your heirs. But one thing you may not think about is your heirs are not obligated to take it. I mean, usually they will. It's a thing of value. They can sell it, you know, do whatever they want to it, right? But there's no obligation for an heir to take it. Same way, in order to sell property, it needs to be two parties, a buyer and a seller. You cannot sell property to no one. So this case stands for the bizarre idea that you cannot abandon property, that you are always the owner. And as the owner, you're liable for whatever fees or taxes may happen. And if you don't pay those fees or taxes, they can actually send a collection against you, right? And what can they do? They can lien the piece of land which is worth nothing. They can put a lien on this piece of land which you can't sell. Eventually, they can probably go after other assets if they can, if they're a priority enough. But this is a very sticky situation, and you cannot abandon property. All right, any questions on this case? Let's see. All right, in the next class, we're going to start a topic on zoning, which is going to be a fun topic. I don't have anything more for today, so have a wonderful day. Stay dry.
For,